and I want to thank Arkansas Farm Bureau for giving us the opportunity to participate in this program. My name is Mark Martens. I'm with Ag Replacements International, based out of Fairview, Oklahoma. We specialize in getting farms approved under the H2A program to hire temporary non-immigrant workers for their operation. So I want to give just a quick background over Ag Replacements. It was begun in about 1998 when the founder Elaine began doing paperwork for her husband, who at the time was a custom harvester with combines and trucks. He went on the run from Texas to Montana or so and just couldn't get local help anymore to go along with him. So Elaine began doing paperwork for him, and that kind of snowballed over the past 20 years. We're currently working coast to coast and border to border for a variety of agricultural operations of varying size and type of operation. We do work for a significant number of farms in the Delta, specifically Arkansas. We really appreciate those folks over there, super good folks to work with, and we've been able to build some impactful and very beneficial relationships. We hope that continues to go on into the future. And so our goal at Ag Replacements, and I think the goal of the program, is to connect agricultural employers that don't have a sufficient domestic labor supply with an able, willing, and qualified workforce. And so when we do that, the employers benefit. Obviously, their operations can be viable and profitable. The workers and their families benefit as well. These workers are coming from other countries, so they can experience a steady job, a fulfilling job, and have some income for the families to live on and enjoy themselves with. So, and that's not to make mention of our country. Obviously, our country is founded on a safe and secure food supply. So our farmers being able to have their operations work is integral to making that happen. And our food supply is secured and our economy is impacted positively when those relationships occur. So if you talk to anybody that files H2A paperwork or anyone that's involved in it, they'll likely tell you that it's complicated and that it's frustrating oftentimes, which is true. But just kind of a broad level look at it, it's a fairly straightforward process. You file through 3 primary agencies in order to get the farmer approved. The first being the state workforce agency, which to this audience would be Arkansas, then the Department of Labor, and then the United States Citizenship and Immigration Services, which is a part of the Department of Homeland Security. So once you've got the farm entity approved to those 3 agencies, you're then good to hire H2A workers, and your workers would go to the consulate, which is a Department of State, to obtain their visas. But basically, to get the entity approved, it's through those 3 agencies you have to get through. And then, of course, you want to ensure that your operation is following all the necessary obligations of the program. We are seeing an increased effort by Department of Labor Wage and Hour Division through walk-on investigations, as well as USCIS through their fraud prevention units, random spot checks, to ensure that employers are complying with the regulations. So for that reason, and for the reason that, of course, it's the law, so you want to comply, you want to make sure that you're staying on top of your game there. And that's what hiring an agent or an attorney will help you do. I'm going to reference you in this slideshow when I'm talking about what occurs. You can replace you with agent or attorney, or you can put yourself in there, whatever fits for your situation. The first part of the process is to file through that state workforce agency, which we call the SWA for short. So before you actually file the state workforce agency, you want to think about what your operation is and get it put on paper. So you first want to decide how is your company structured? Are you an individual employer bringing workers to work on your own farm? Are you a farm labor contractor bringing workers in to provide services to others? Are you a joint employer, an application with multiple farms on one application, or are you an association of farms? Once you decide what angle you're coming at with regard to your company structure, you then want to ensure that you complete the ETA 790 with all the necessary information that accurately reflects what the job opportunity is. That would consist of your job description, what the workers can expect to be doing, the approximate hours per week they'll be offered work, the contract dates, so when you actually need the workers. And a side note on that is that the H2A program is limited to 10 months per need, basically per entity, so you can't hire workers for a year-round need. The job order needs to disclose the minimum pay rate that will be available to workers that have the experience requirement, where the housing is, where the work sites are, just whatever details need to be on there to ensure that if you handed that to someone, they'd be well apprised of what the job opportunity is. Once you got that all together on the 790, that gets filed to the state workforce agency no more than 75 days and no less than 65 days from your start date of need. So basically there's this 15-day window where you can actually file that job order to the SWA. There are some exceptions to that if you've not used H2A before, or if you've had some unforeseeable events happen to your operation. You can request a waiver of that filing window. So if you're someone that's interested in a program and you think 60 days is too far out, there's a possibility that you could have that waived. But just generally speaking, those are the 15 days you have to file your application. When the SWA receives the job order, they'll commence their review and look at a number of things. First, they'll look just to see if that 790 has all the necessary information filled in. So do you have all the blanks filled in? Are the housing details good enough to let a worker know what type of housing they'll live in? Do you have at least the minimum wage rate that you're allowed to put on the job order? Just kind of verify that it seems to be complete. They'll then take a look to see, are the job duties and the minimum experience requirements normal for the area? So if you're filing to raise cotton in Oregon or to raise penguins in Arkansas, the SWA is likely not going to approve that job order. Whereas if you're looking to raise corn and soybeans and rice in Arkansas, and you say that in order for a worker to be hireable, they need to have 3 months of experience operating farm machinery, that's likely going to be a job order that the SWA thinks that it can approve, as long as the remainder of the job order meets the requirements that they need to see. I will also say that the scrutiny applied by the state workforce agency to the job order varies by state workforce agency. So some request or require certain assurances that maybe others don't, but generally speaking, they're looking for the same principles. They're looking for the same information on there. Once the SWA has determined that they can approve the job order based on the details you've provided, they'll place the job order into what's called an interstate clearance system to begin recruiting for U.S. workers. So if a worker goes into an unemployment office or into a job fair or something where they're looking for work and there's access to this system, they could potentially be referred to your job order if they meet the minimum qualifications necessary. And that's a super important thing to take note of, is that the goal of the H2A program is to protect the domestic labor supply. So we know that there's not many workers looking to work in ag, and the number of referrals to ag job orders is very marginal. It's been well documented that even in the COVID pandemic and amongst the unemployment numbers we've seen, there's been even fewer referrals to ag job orders. So generally, people don't want to work in ag, but there is always a potential that there might be workers interested and qualified, and you certainly have to consider those workers for hire prior to H2A workers. Lastly, the SWA will work with you or your agent and the housing inspector to conduct a housing inspection and ensure that that meets the standards necessary.
So you talked early on, 75 days out is when when your clock kind of starts. What all does a producer need to do in preparation of getting to that 75 before we start the clock on this?
Sure. So in our office, and let me just say, in our office, we like to have paperwork ready to go 90 days ahead of the start date. So for a recurring employer that's filed before, we like to be sending them the application 90 days ahead of the start date so that they can get it back to us and we're ready to go on that very first day. Obviously, if there's an employer interested in using the program and they're needing to get someone over here as soon as possible, or maybe even if they're kind of looking towards the future and they want to be able to shoot for that 75-day mark, they want to ensure that they have a workers' compensation policy in place, because that obviously takes a little bit of time. They want to make sure that they actually have a federal ID number. So we have a lot of farmers, well, they'll call us and they'll say, I just filed a Schedule F under my name and my social. You do have to have a federal ID number to participate in the program. And then I think the last thing would be, in order for them to get to that 75-day mark, they just need to have a good idea of what they're looking for, so that when they contact their agent or attorney about getting that process started, they can get going on the paperwork rapidly and like I say, kind of get that operation on paper. But I'd say the primary things that we see hold people up are the federal ID number and workers' compensation. And let me throw one more in there, housing, because you do have to be able to put the housing location on the application when you file it. Department of Labor used to be pretty lenient on making post-certification housing amendments. So I would never advise this, but if a farmer put a house on the application that they thought they were going to be able to make work, but maybe wouldn't be able to, they could put it on there. And then if they got closer to having the workers here and they needed to change it, they could just change it. Department of Labor has tightened that up a little bit, and they're basically saying that they won't allow those amendments unless the housing has become unavailable through no fault of the employer. So I guess to recap, the federal ID number, the workers' compensation, a general overview of what the job is, just have that ready and have the housing ready to go. Once the SWA has approved that 790, you can then file to Department of Labor. And the form that gets filed to Department of Labor is called ETA 9142, which gets submitted to the Chicago National Processing Center, or we call it CNPC for short, no later than 45 days from the start date. So you've got this 15-day window to file the state workforce, and then roughly, depending on when when in that window you get your job order submitted and when it gets approved, you've got another 15 days roughly to get it filed to Department of Labor. And like I mentioned with the state workforce, same way with Department of Labor, that request to waive that 15-day filing window is possible. So the 45 days may not actually apply if you're requesting an emergency waiver of the filing window. As the Department of Labor is reviewing the application, they'll look to ensure that it's in compliance with the regulation and program requirements. So they want to make sure that there's not any improper disclosures on there that are contrary to the H2A program regulations. They want to ensure that the appropriate disclosures that are required and that must be clarified are on there. They want to make sure that your job description is actually agriculture and actually qualifies for H2A. And that's something that we've seen Department of Labor focusing on recently. They want to make sure you don't have any improper deductions. And then they'll also look for typos or things of that nature that the SWA may have overlooked. If they do find errors in your application, they'll send you a notice of deficiency, allowing the opportunity to provide corrections, amendments, or further clarifications to get those taken care of. Another thing Department of Labor has been focusing on is to determine whether your need is seasonal or temporary. So like I mentioned before, the H2A program limits you to 10 months maximum per need, basically. And so your need either needs to be seasonal in that it's tied to a growing or production season, and it's not a year-round need, or it needs to be a temporary need that's not going to be a recurring year-round need. Lastly, the Department of Labor will determine through correspondence with you or your agent and the state workforce that there aren't sufficient U.S. workers. Basically, you as the employer will turn in a recruitment report letting the Department of Labor know whether you've had any applicants, and the SWA will turn in a report letting the Department of Labor know whether they've referred any applicants. And there again, when I say you, I mean you or your agent or attorney or whoever's helping you. The SWA will also turn in the results of the housing inspection and ensure that it's satisfactory. If there wasn't an inspection, they'll require some additional housing assurances from you. They'll request that you provide them workers' compensation, which is in effect for the duration of the contract. And then there may be some other supplemental documentation that the Department of Labor needs. Once they have all that, they'll certify that application by no later than 30 days before the start date. I'll just provide a couple of examples of some other documentation they might provide. If you're filing as a farm labor contractor where you're bringing workers to provide services to others, there's an additional requirement where you have to get your company licensed as a farm labor contractor, and that involves obtaining a farm labor contractor license, as well as you would have to obtain a surety bond. You have to have an itinerary of the farms you're going to work for. You have to have written work agreements with those farms. So you'd have to provide all that to Department of Labor. And Department of Labor may request some additional written assurances as well. But once they've got everything they need to see, the job has been posted in interstate clearance by the state workforce. Department of Labor determines that the job qualifies for H2A and that it's complete, they'll issue you a temporary labor certification. And that kind of takes us to the last step in the process, which is to file to U.S. Citizenship and Immigration Services, or we call it USCIS for short. When you file to USCIS, you submit Form I-129 along with that temporary labor certification that I mentioned from Department of Labor. When USCIS is reviewing your petition, they'll look to see whether the petitioner, which is the company, and the beneficiaries, if there's any listed, are legitimate. So this is something we've seen them focusing on, is they'll look up online, see if your company is registered, see if you're an active business, that you actually control your work site. They'll also look to see that your job description is agriculture in nature, but they just want to make sure that they're approving a company that's actually going to bring workers over on real visas connected to a real agricultural job. There's two ways you can file that Form I-129. One is for unnamed workers, which is when you're bringing workers from their home country and you're not naming them specifically. The other is for named workers, which is when you name the workers you want to hire. If those workers are, generally this is done when workers are in country and they're already here in the United States and you want to transfer them to your temporary labor certification, it can be done when they're out of country as well. But when you name workers, specifically when you're trying to transfer workers that are already in country, USCIS will undertake some additional review on those beneficiaries to ensure that they're not going to hit something called the 3-year limit. And so just generally speaking, an H2A worker can be in the United States for up to 3 consecutive years without ever going home, and then they've got to go home for 3 months. So if a worker is transferring to your labor certification and they're going to exceed that 3-year limit, USCIS will pull them out of the transfer and ask for further clarification or just tell you that they can't be transferred. There's some additional calculations to the 3-year limit and how it applies. For the purposes of this overview today, I'm not going to go into those further. That's something that your agent or attorney that you work with should be able to help you out on. Once that's all done, USCIS will issue your company the final approval called the I-797B, and that is your final approval to hire foreign non-immigrant workers under the H2A program. At that point, the review and approval of your company has been completed. And those workers can take that final approval along with some other documentation to the consulate and obtain their visas and come over and start working for you. I know there's a couple of other speakers that are going to be involved in this program that are going to touch on some of these details here. So I'm not going to go really in depth, but I want to touch on some of these important obligations to take note of. When you agree to participate in the H2A program, you agree to pay your domestic workers in corresponding employment and H2A workers the maximum of the federal or state minimum, the collective bargaining, the prevailing wage, or the adverse effect wage rate, which we call the AWARE for short. As an H2A employer, you must provide housing at no cost to the workers, so you can't charge for rent or utilities or anything of that nature. It needs to be furnished with bedding, pots and pans, furniture. Basically the workers need to be able to move in and start living in it. You must provide cooking and eating facilities, so a kitchen or 3 meals per day to the worker, depending on what your housing allows. So if you have a house, generally you can probably offer them a kitchen. You don't have to purchase their groceries. As long as you give them away to the grocery store, you can just provide them the cooking and eating facilities. If you're keeping workers in a house or in a motel or something that doesn't have a kitchen or a kitchenette, then you would need to provide the workers 3 meals per day. You're responsible for the transportation from the worker's home in their home country to your farm and then back to their home at the end of the contract. So if the worker buys their bus or plane ticket up front, you need to ensure that you reimburse them for that, or you can purchase those transportation costs or pay for those transportation costs from the beginning. Each worker will have a consulate fee of $190 when they schedule their consulate appointment to obtain their visa. That needs to be borne by you, the employer, as well as while they're traveling to your farm and back home at the end of the contract, you must reimburse them for some subsistence rates, which you can think of that in terms of meals. Right now it's $12.68 per day if the workers don't provide you receipts, up to $55 per day if they do provide you receipts. If you work with a recruiter and they've got a fee, you want to ensure that you bear that cost and any of the costs associated with that. As we mentioned previously, you do have to have workers' compensation or the state equivalent in effect for the duration of the contract. So you want to ensure that you maintain that work comp. And an important one is to ensure that you offer employment to any qualified, able, willing, and available domestic referral or applicant that applies for the job prior to hiring an H2A worker. Just a few more here. There's something called the 3-quarter guarantee, which is from the first workday after the worker gets to your farm to the contract end date. You must guarantee the worker 75% of the overall contract hours, which is based on that anticipated hours per week that we mentioned you'll have to put on the 790 when you file to the state workforce. You must maintain good records. It's a big thing about H2A. You want to make sure you have everything in writing and make sure you maintain good records. So you need to keep a record of your workers' earnings, and you also need to provide to the workers on or before each payday a record of their earnings for that pay period. And there's a certain set of information that you have to provide to them, which I didn't include here. You cannot plan to lay off and must not have laid off recently any domestic workers in order to hire H2A workers. If you do work with an agent or an attorney and there are fees associated with those services, there again, you want to ensure that you as the employer bear all those expenses. And then lastly, you want to make sure that you keep good records, that you keep them in a location where you can easily access them for a period of at least 3 years. Like I mentioned at the beginning, when you get a wage and hour investigation or a Department of Labor paper audit, which is where they send you something in the mail requesting some records, it's really nice to be able to have those in an easy spot for you to access to provide at that time.
So if I'm a new farmer wanting to utilize H2A workers, when do I need to start? When do I need to contact you? How long is the process leading up to that small window that we're talking about?
Yeah, we would say 4 months in advance, 4 months in advance of the start date.
Of the start date. Okay.
Whatever the start date is, we would like you to contact us 4 months in advance. That being said, Matt, we have new employers call us all the time where they're right at their start date or they want somebody tomorrow or whatever the case may be. So I'm not saying it has to be that way. That's certainly not a requirement of our office either. Just if they've got the time and they're looking, let's say they're looking towards spring 2021. Okay, so for a February start date, we'd be filing that somewhere in, I don't have my paperwork in front of me, but somewhere in mid-November. So it'd be nice if they were contacting us in August, to get going so we can start filing the paperwork in November.
And you talk about, your screen here says we do not recruit or solicit hire workers. How does a farmer find a worker in Mexico or South Africa, something like that?
That's an excellent question. So, and that's just purely referencing aggregate placements. We are not strictly recruiters. We do have very close ties to recruiters, especially in South Africa that we work with, but also in Mexico, Nicaragua, Romania, etc. I just want to make note that we are not recruiters. There are some H2A agents who, and one of my fellow speakers here, I believe is more directly tied to recruiting. So it's not to say that no agents are recruiters, but in our office, when we have a new employer interested in a program, contact us. We'll put them in touch with a recruiter, and then they can start working with that recruiter to figure out what workers do I want to hire. One thing I will also make note of is a good recruiter will not only send resumes, multiple resumes for farmers to kind of look through, but they'll also set up Skype calls, or I guess anymore it's Zoom calls. They'll get them in touch on WhatsApp so the farmers can visit with the workers, because you can tell a lot by visiting with someone rather than just looking at a resume. So ultimately, the farmers we work with pick the workers. A worker just doesn't get sent to them. They get to kind of have that process facilitated through a recruiter, but then they would pick the worker that they want to hire. And I will make a note as well that anymore, with the increasing popularity of the program, especially in a state like Arkansas, if an employer is interested in using the program, it's likely that they already know someone using the program. And that we always encourage them to reach out to those people as well to see if they've got a recruiter that they've been pleased with, and maybe even they've got workers they've been pleased with that know other workers in South Africa or Mexico or wherever they're looking to get workers from. But yeah, so basically that's just the recruiters in those countries are better established to work with a farmer directly, kind of one-on-one, in getting workers selected.
Can I get my same worker year in and year out if I get somebody I like?
Sure. Yes. And I would say that's the goal of I don't know, I don't want to make a percentage up, but the vast majority of employers we work for, that's their goal. They want to be able to get somebody in their operation. They get them on their air seeder, they get them on their sprayer, they get them on their combine. The worker knows what they want in their operation. Farmers can be particular, not all are, but as you know, farmers can be very particular. And so you get a guy in your operation that knows how your operation works, and you don't have to watch over him all the time and tell him what to do. That's massively beneficial. So yes, you can certainly bring a worker over year after year.
Okay. All right.